Hello friends, as you are aware that Hammurabi tablet has once again started its original program as to how to practice in various laws. Now today we have a topic as to how to practice in service laws, and for that we have with us Advocate Rajeshwar Panchal sir, who is practicing in these particular laws since last 18 years. So we'll interact with Panchal sir and we'll come to know as to how to do a practice in service laws. Panchal sir,
Thank you.
you are most welcome. Thank you for sparing your time for us.
Yes.
Sir, we would like to know what is this service laws, how they are practiced, which are the codes. Please tell us about that.
Yes. Thank you. In fact, service law is a part of our constitutional law. It is also called as administrative law. In fact, the Constitution of India provides Article 309, and that confers powers upon the governments to make the laws or the rules with regard to the conditions of the service.
Oh.
When somebody enters into service, his services are regulated. How to get promotion, under what circumstances he will be subjected to departmental inquiry, suspension. There are various such issues, and to deal with those issues, even there is a requirement of prescribing the qualifications. So for that we have recruitment rules. So whatever kind of rules that are in the place, that are made because of the power given by the Constitution of India to the respective government.
Okay.
Similar powers are also given because service law is not only limited to the government servants. We have public undertakings, we have corporations also. So even those corporations or even the banks which are controlled by the government, so even all these establishments, by whatever name they are called, if they are having the instrumentality, the character of instrumentality of the state, like they are agencies of the state, they will have the regulations in place. They are known by whatever sometimes we call discipline and appeal rules, we call conduct rules, we call pay rules, we call leave rules. By various names there are different rules in place. So issues arise often out of these issues. And as far as the government servants are concerned, initially in the inception, maybe when we did not have the tribunals, the civil suit was the proper remedy.
Okay.
When somebody was, say for example, removed from service or dismissed from service or with any other punishment, then in those times civil suit was to be filed in the court, and ultimately by way of first appeal, second appeal, matter used to come to High Court and then Supreme Court in the normal circumstances. But after we have amendment in the Constitution of India, we have introduced article, I think 323 B and A something, and that has empowered the Parliament to make the law, and in exercise of that power, Parliament made the Administrative Tribunals Act 1985.
Okay.
Thereafter we have a central administrative tribunal at the center, which governs the government servants of the central government. And apart from the government servant, there are various societies, various public undertakings, various other autonomous bodies which are controlled by the government and which are a state within the meaning of Article 12. Even those establishments have also been brought under the purview of the Central Administrative Tribunal.
Okay.
In the same act, there is a provision that every state will have its own tribunal.
Okay.
Therefore, in Maharashtra, we have Maharashtra Administrative Tribunal, and those who are employed by the government of Maharashtra will go to the MAT.
Okay.
Even those who are participating into selection process and any issue arises out of the selection itself, then even the participants who are desiring to go into the service of government of Maharashtra can also go to the MAT with their whatever grievances.
Okay.
So this is the overall situation. Now let me tell you, there are some other employees, set of employees who cannot go to the MAT, who cannot go to the CAT.
Okay.
Then for them, for example, now we have universities, we have colleges, we have in university or colleges we have teaching staff and non-teaching staff.
Correct.
Okay. As far as teaching staff is concerned and non-teaching staff is concerned, we also have the college and university tribunal under the Maharashtra Universities Act.
Okay.
So those employees can go to that tribunal. However, the jurisdiction of that tribunal is limited only to the supersession
Okay.
and removal or termination of service or dismissal of service. In respect of other issues, they will have to directly come to the High Court by filing a writ petition, simpliciter.
Okay.
These. Similarly, we do have the schools in Maharashtra which are not falling into category of college and not affiliated to any university. For that, we have a separate law made by the government of Maharashtra, that is called MEPS Act. That is Maharashtra Employees of Private Schools,
Okay.
1971. Under that, there are rules also. Those rules provide for the service matters, conditions of service, and under that act, there is a school tribunal.
Okay.
So the employees, either teaching or non-teaching, employed in any school which is having the grant in aid or even not having the grant in aid, they are governed by that act of 1971, that is MEPS Act, and the rules there under. So those employees can go to that tribunal, school tribunal. So this is overall. And let me tell you again, we have Army, we have Air Force, and we have third Navy. So for them, we have a separate tribunal, that is called Army Tribunal.
Okay.
In Bombay, we have that AFT, that is Armed Forces Tribunal.
Okay.
So the employees, and particularly, interestingly, only those who are in actual Navy, that is on the field, that is Armed Forces, only they can go to the Armed Forces Tribunal.
Okay.
Now in Army or Navy, we have civilians also
Yes.
doing clerical work, etc. So they can go to simpliciter CAT.
Okay.
So only Armed Forces, even CAT, the Administrative Tribunal Act makes it clear that this act will not be applicable to the armed forces. So apart from Navy, Air Force or Army, we have other armed forces also.
Correct.
Like Tibetan Force, Border Security Force. So as far as those employees are concerned, they can go to only High Court, because they cannot go to CAT, they cannot go to even AFT, that is Armed Forces Tribunal. So they will have the only general remedy, that is filing a petition in the High Court. So this is overall, situation of the service matters.
So it's actually a very vast field.
Yes, it's very vast.
Vast field.
Yes.
Sir, what are the laws which are applicable to this? Like, which can, the names of those laws, because we are not aware of that.
Yes. To make it very simple to be understood by our viewers, we will first take example of the central government employees. Okay. So then we will come to the state, and almost all other state governments have copied the rules made by the government of India. Okay. Now in the government of India, we do have conduct rules, that is called CCS conduct rules.
Okay.
Central Civil Service Rules, in bracket conduct rules. So these conduct rules are very important. How a government servant should behave, how his conduct should be once he becomes the government servant. This is regulated by that conduct rule.
Okay.
Similarly, there are pay rules. When we get pay commission, there is a pay commission after every 10 years. Like presently we have pay commission, 7th pay commission, which has come into effect from 1/1/2016.
Okay.
Once that pay comes into existence, the existing pay rules are modified according to the latest position as recommended by the pay commission. So that is governed by the pay rule.
Okay.
Now government servants will have right to have the leave also. For that we have CCS leave rules.
Okay.
For example, somebody has violated the conduct rules. He has not behaved up to the mark as per the conduct rule. Then what is to be done? How should be proceeded against him? For that we have a separate, that is CCS CCA rule.
Okay.
That is Central Civil Services Classification and Appeal Rules.
Okay.
So that provides the actual procedure to be followed before imposing the punishment. And in that we have several, normally there are two kinds of major punishment, penalties. We have a set of major penalties and we have a set of minor penalties. In the major penalty, generally there is a dismissal from service, removal from service, compulsory retirement from service, and reduction into rank.
Okay.
Now dismissal is one of the harshest penalty. When government servant is dismissed from service, he becomes disqualified to be employed again in any government sector.
Okay.
Very serious penalty. And then removal. Removal does not carry the stigma or blot like disqualification forever, but still you will lose everything.
Okay.
So when government servant is either dismissed or removed from service, his entire service will stand forfeited. That means he will not get pension, he will not get gratuity,
Okay.
he loses everything. So these are the very dangerous penalties In fact, these are called civil death.
Okay.
Because when somebody is deprived of his very livelihood, it is actually a death, civil death. So these penalties cannot be imposed unless the procedure laid down in the law is followed.
Okay.
And then we come into play, then the very principles of natural justice. In fact, in India, the expansion of the concept of principles of natural justice is only because of the service law.
Okay.
That is, service law has played a major role, a greatest role in expanding the role of the principles of natural justice.
Okay.
And the limitation of the court to interfere into these kind of inquiry matters which result into ultimately dismissal or removal from service or say compulsory retirement is again because of Article 311, because Article 311 gives, that is very say for a common man we have Article 21, isn't it? So Article 21 says that nobody can be deprived of his life or liberty except according to procedure laid down in the law.
Correct.
For that we have CRPC.
Yes.
Okay. According to CRPC, one has to be prosecuted.
Correct.
And he has to be given fullest opportunity to defend himself.
Yes.
And then only, if at all the case is proved beyond the reasonable doubt, then court can impose the penalty.
Yes.
Similar to that, there is a protection available to government servant also. So these penalties cannot be simply sit and imposed simply because employer wants to punish somebody with the penalty. It cannot be done. There must be a procedure.
Okay.
So these rules, that is discipline and appeal rules or CCA rules, will have to be read in the context of Article 311.
Okay.
Now again in Article 311 there is one major protection. Rule is basic rule is that the civil servant cannot be dismissed, removed or compulsorily retired or reduced into rank except by the authority by which he was appointed.
Okay.
Or by the authority to whom the appointing authority is subordinate. That means in simplicity, a person who is subordinate to the appointing authority cannot impose that punishment upon you.
Okay.
That is the protection.
Okay.
And then that means simply, suppose I am appointing somebody, that means I have got power to remove him also, dismiss him also. Somebody who is below me cannot do that.
Okay.
So one who cannot appoint cannot dismiss also. That is a logical conclusion.
Okay.
But then next protection comes into play. Even I, who appointed, cannot dismiss unless I follow the set of procedure in which that fellow is given the fullest opportunity to defend himself.
Okay.
That is the embodiment of the principle of natural justice by virtue of Article 311.
Okay.
311. And then then actually the principles of natural justice are so vast and they are expanding by day. So we cannot say that this is a straitjacket formula and that has to be followed in each and every case.
Okay.
In every case, the circumstances are so different. Then in the set of that fact or the circumstances, we have to analyze the situation and come to conclusion whether there was a violation of any of the principles of natural justice. Now, you must be aware, basically, originally principles of natural justice were having only two principles. That is, nobody can be judged in his own case, and secondly, nobody should be condemned unheard. These are the two original concepts, original principles, but then over the period of time, those principles have given birth to new principles also. Now today, the principle of natural justice is also that justice not only should be done, it must appear to be also done. That means a person who is the subject matter of the inquiry or subject matter of any action, penal action, must have a faith or must believe that he is given fair opportunity, that he is not victimized. He must have that fairness in his mind, and for that the authorities concerned should display the fair play in the action. So these are the requirements, and sometimes it also happens that the rules under which the inquiry goes on or the action is taken against the employee do not mandate the applicability of the principles of natural justice. Then Supreme Court of India, in famous case, there is one famous case, Union of India versus Krishna Kunj Bihari. In that case, Supreme Court said that the principles of natural justice must be made applicable even when your rules are silent. Unless the rules themselves expressly exclude the application of the principles of natural justice, the principles of natural justice must be made available. But let me tell you beyond that, it is impossible that rules will expressly exclude the applicability of the principles of natural justice.
Yes.
Because if the rules do so, rules will be directly violative of Article 14.
Correct.
Because principles of natural justice have been held to be part of Article 14 itself. If the government makes a rule which excludes the applicability of the principles of natural justice, it will be hit by the Article 14.
Correct.
So therefore, even when rules are silent, rules do not say anything, the principles of natural justice are must to be followed. In any kind of action, not only in departmental action. There are other actions also. For example, when somebody is entering into service and he doesn't fulfill the probation, initially probationary period is 2 years, 3 years. In those cases, departmental authorities, without holding inquiry, simply sit and issue the order of termination. Simply sit the termination without saying anything that he has done this and that. They will say, since your service is not satisfactory, we are giving discharge from service. We are terminating your service. We do not anymore require your service. Like that. Even in those cases also, these principles come into play.
Okay.
So we have these states. Similarly, on the same line, Maharashtra government, we have also MCS, that is Maharashtra Civil Service Conduct Rule. We have Maharashtra Civil Service Discipline and Appeal Rules.
Okay.
Maharashtra Civil Service Pay Rules. Maharashtra Civil Service Pension Rules. Similarly, we also have CCS Pension Rule. We have Maharashtra Civil Service Leave Rules. So these are the rules in place. And similarly, the public undertakings, they have almost copied what the government of India has framed, because that is ideal. And they copy normally. For example, let us take example of the MTNL. When we go MTNL or BSNL, they say CDA rules, that is conduct, discipline and appeal rules. So they will provide each and everything in respect of the conditions of service. They will have the recruitment rules in place. So recruitment rules will lay down the qualifications. For example, they want particular employee on a particular post. What shall be qualification of that post? According to that, then selection process proceeds. So these are the different laws. As I told, there is the Maharashtra Universities Act. Under the Maharashtra Universities Act, there are statutes made by the university.
Okay.
Those statutes will be like these conditions, conduct or discipline and appeal rules. Now in Maharashtra, we have Mumbai University. So Mumbai University has a statute. Statute number so and so, statute number so and so. It is like just regulation. So they provide the procedure for holding inquiry, for imposing penalty, okay, for even promotion, etc. Now, as I said, in respect of the schools governed by the MEPS Act, we have MEPS regulations, service conditions of 1981.
Okay.
So now, interestingly, let me tell you one very interesting case which I handle to make the point very clear. If there are no rules, what happens? Okay, I got a case where 4 professors were dismissed from service.
Okay.
It was from Pune. And when the case came to me, I found that the charge sheet did not contain any rule. Charge sheet did not mention or refer to any rule. Then I argued that unless I know, or unless you tell me that by doing so and so activity I have violated this law, how come I will be in position to defend myself? Because in the rule of the in the procedure of the inquiry, initially you are given a charge sheet.
Okay.
Like in the criminal court, we file a charge sheet after carrying out the evidence during the investigation. Charge sheet is submitted. But in the departmental inquiry, sometimes preliminary inquiry is done to find out whether there is a case to be proceeded further. And if the material is available, it is made out that there is some material and he can be subjected to departmental inquiry. Then he is given a charge sheet.
Okay.
Sometimes we call it as a memorandum of charges, sometimes we call it as a charge sheet, sometimes we call simply memorandum. So in that, no, charge is specific charge. For example, you so and so on so and so date, on so and so time, so and so place have done this, which is amounting to misconduct within the meaning of this conduct rule.
Okay.
There must be such a specific and clear charge so that he knows what he has to defend himself.
Okay.
So these are the rules, and if the rules are not there and then somebody is subjected to departmental inquiry, that is a gross violation of principles of natural justice. So on that one count itself, the department had to take the entire dismissal order back.
Okay. So they were reinstated.
They were reinstated on this one count. So this is the importance of the rules being in place.
Okay.
Because if there are no rules, then you cannot say that I have violated rules, isn't it? So this is actually coming from Article 20.
Okay.
You must be aware of Article 20. Article 20 is very important, but that has been now made applicable to service jurisprudence also. Originally it was made keeping in view the criminal jurisprudence. Now Article 20 says first that nobody shall be made to punish, nobody shall be made to suffer the penalty unless the act which he has done is declared as a punishable offence by the law. So there must be some law in place. That law must declare that doing this particular act shall be an offence, and that very law must provide the punishment also. Then only if somebody violates that law and commits an offence within the meaning of that sense, then only he is to be prosecuted and punished according to that law. Same principle also applies in the departmental matters also. So there must be some conduct rules first, and then I must be made, accused of having committed the misconduct within the meaning of that conduct rule. If that is not done, then it is a case that somebody is being brought in the court and we tell him, you defend himself. He doesn't know what to defend. So he will have to say, I did not commit rape, I did not commit murder, I did not commit this offence. So he will have to keep, this is not possible. So he must be told, like in the criminal case also, the magistrate or the court while framing the charge, specifically makes a charge.
Yes.
So the same principle is also applicable in the departmental matters, and that is called charge sheet.
Okay.
So this is the overall idea about the service rules.
Sir, you have been saying that departmental inquiry is started. Now I want to ask that whether any advocate can assist that particular employee during the departmental inquiry.
Yes. That is actually very important and significant also. One case from our Bombay went to Supreme Court. That is very famous case. I think BPT versus Surendranath Nadkarni. Okay. And let me tell you, in that case Supreme Court referred to one of the beautiful sloka of Bhagavad Gita. That slok goes like this: Sambhavitasa cha kirti marnadati richyate, which means that for the man of honor, for the man of respect, dishonor or disrespect shall be worse than death. This is let me tell you the context in which this is this sloka comes into Gita. On the battlefield, when Arjuna lays down his weapons, saying that the enemies are my own people, my own relatives, and I do not want to kill them, and by killing them what ultimately I will gain. He is not ready for the war. Then Lord Krishna tells him, see Arjuna, you are the greatest warrior, particularly in respect of archery, but there are people who are trying to find the opportunity to say that you are not warrior. So you have that respect and honor of being a greatest archer in the world, and if you do not do that, that very honor will be taken away from you, and when a man of honor is losing that honor, for him it is worse than death. So that is the advice given to Arjuna. So this slok is used by Supreme Court while dealing with such a case important. Because when somebody is subjected to departmental inquiry, somebody is made accusation that he has violated this, and he is subjected to inquiry. Ultimately that inquiry may result into dismissal from service, removal from service. As I said, removal or dismissal from service will mean the taking away of the livelihood itself. He will have no means to sustain. And that person who is facing such a great accusation, such a great blot, at this point of time, let me remind you that Article 21, that is right to life, also includes right to reputation. Because we have been often hearing रंकाला देखील तेवढीच राजा एवढीच इज्जत असते.
Correct.
We have that saying in our local language.
Yes.
The king has reputation. Similarly, even a person walking on the road has the equal reputation.
Yes.
And that has been also recognized by Article 21. And when somebody is made such accusation that he has violated this particular rule, he is facing the inquiry is going on, he is living in the society with that accusation on his head. So he loses the reputation itself.
Okay.
when departmental inquiry has such a greatest harsh effect on his personality, his reputation, then we must have the, the fair action in place. And in that sense, he must be given the fullest opportunity. In that case, what had happened? He had demanded that I must be allowed to have the legal assistant to defend myself in the inquiry. He was not given that.
Okay.
Saying that our rules did not contemplate it, that the delinquent employee, that is employee who is being subjected, does not have right to engage a lawyer in the departmental inquiry. But interestingly, what had happened, while the inquiry was going on, these rules got changed. The very rules got amended, and there was a provision that if the department is being represented by the legal assistant or somebody with the legal brain, may not be exactly a lawyer practicing in the court, but somebody having the degree of law,
yes,
and dealing with the departmental legal issues, even if such legal brain is available with the department to represent their case, in that case he is also entitled to get the lawyer. So this was the position, new position. Then department suo moto should have considered his request on account of the new policy, and department should have given the lawyer to him, but department did not do. Matter went up to Supreme Court. Supreme Court said, when your rules got changed, amended, and you are being represented by somebody who is having legal brain, you have denied this opportunity to this fellow, therefore your entire inquiry got vitiated.
Okay.
So on that one count, his dismissal order, his everything was set aside by Supreme Court, he was reinstated in service. So today we have a very clear position that if department is having the assistance of the legal brain, employee is also equally entitled to have the assistance of the legal brain. That is the law today.
Sir, how is the filing procedure in this CAT or MAT?
Yeah. Actually, Maharashtra Administrative Tribunal, if you get that book, even Bare Act, under that you will have rules also, and those rules have prescribed a particular format.
Okay.
And the format is just like the format you might have handled the cases of DRT. So in DRT also there is a format. Nowadays this is a new style. Earlier there was no importance attached with the format. Earlier we used to say what has to be seen is the substance, not the form. That was the earlier policy. Okay. In what manner you have written is not important. What is important must be written, and that must be found. That was the earlier policy. But now, since we have the new rules in place, so the rules are providing the format itself. So generally in the CAT or the MAT, format is the same, only name changes.
Okay.
In Maharashtra we say Maharashtra Administrative Tribunal, and in CAT we say the Central Administrative Tribunal. Okay. Now the format goes like this: the heading, that is Maharashtra or Central Administrative Tribunal, then original application name, that case in High Court we call writ petition, that is called original application. Then you have to put down the district from which your case is coming. For example, Bombay, Pune, whatever it is. Then particulars of the applicant, that is, in that you have to give title, that name, the post on which he is working, and his age and residing address and the official address. Then the respondents versus so and so, so and so, so and so. Then first para provides, in short you have to tell what is the case in that first para. For example, order against which the case is made. Sometimes there may not be order. It is not necessary that in every case you are challenging an order of the authority. You may feel aggrieved because somebody is promoted and you are not considered. In that case also you can go to the CAT seeking that yes, I am entitled to promotion according to my seniority, but that fellow is. So you have to narrate in short, he is aggrieved by the action on the part of the respondent in promoting so and so fellow without considering my seniority. So in that particular para. Then second para goes like that the tribunal has jurisdiction to try the case. Third para goes on to say that the matter is filed within limitation period. And normally limitation is of 1 year. In approaching CAT or MAT, there is limitation of only 1 year from the date of actual cause of action. Now this 1 year has to be reckoned not from the original order. Say for example, before going to CAT or MAT, in fact I have forgotten to tell you that there are departmental remedies also under the rules. And those departmental remedies are like appeal and revision. But the departmental remedies, for example, now in Maharashtra, let me give example of the police department. Now CP is competent authority to impose penalty upon the constables in Mumbai. That is Commissioner of Police. Suppose he passes an order of the removal from service. The constable is entitled to prefer an appeal departmentally, and that departmental appeal will go to the DGP, that is Director General of Police. And then he can make a revision to the Government of Maharashtra Home Department.
Okay, then to
Then
MAT.
after exhausting these departmental remedies, only one can go to MAT.
Okay.
If you directly go to MAT, MAT will say that you have not exhausted this remedy, and accordingly your case is not maintainable as of now. You go and first exhaust. Okay. Now there is an exception. When you have preferred the departmental appeal and the period of 6 months has lapsed and there is no action, no decision, law will presume that you have exhausted that departmental remedy, and you are free to approach the respective tribunal. Okay. And then para 4 goes on facts of the case. In the facts of case, you know, we have to go on telling the story like situation, who is he, how it happened, everything. Then para 5 pertains to grounds on which you are challenging the action. Then para 6 and 7 pertain to that you did not file any other case and no case pending, no decision, etc. And para 8 is the prayer. Para 9 is the interim prayer, if you make an interim prayer like stay, etc. And para 10 provides particulars of the, now let me tell you, in MAT or CAT we do not pay the court fees.
Okay.
We pay Indian postal order, that is 50 rupees postal order. You have to get purchase from the post, and that has to be annexed, and that postal order has some particulars like where from you purchase, what is the date and what is the number. So you have to, and that format says that you have to put down those particulars in the same, and then verification. So this is the format as applicable to MAT or CAT. Now if you go to High Court, the normal format of the writ petition is to be followed. Okay. So in University Tribunal, where also we go to file appeal, or school tribunal, there is also no such specific format provided, so you can follow the style of even writ petition. In University Tribunal or the school tribunal. That is that you are free to have whatever style of format of the drafting you can follow.
Okay.
Yeah.
And sir, the order passed by MAT or CAT,
Yes.
that is challengeable in High Court?
In High Court.
But
Yes.
as a appeal or in writ?
Yeah, this is also very interesting. This is also very interesting. Actually, what had happened? The Act says that the orders issued by the MAT or the tribunals under the Act will not be challengeable in any court except under 136, Article 136 of the Constitution of India by way of special petition. Article 136 says, and Article C, filing a petition in Supreme Court under Article 136 is not your right.
It's not the right, correct.
It is the discretion of the court. So court may grant leave to you, may not grant leave to you.
Correct.
If at all court grants leave, then that very special petition gets converted into the regular appeal. Okay, this is the position of the Supreme Court. So that was the position made by the statute with regard to the tribunal cases. This provision came to be challenged. The constitutional validity of this provision came to be challenged in Supreme Court.
Okay.
Very famous case. I think L. Chandra Kumar versus Union of India.
Okay.
And in that case, Supreme Court said that this provision is unconstitutional. And Supreme Court said that because why this provision is unconstitutional? Because by making such a provision, the powers of judicial review, which is vesting with the high courts, was destroyed.
Correct.
And judicial review is one of the basic structure of the constitution. High court cannot be deprived of its basic judicial review. Then making such a provision that the order cannot be challenged in the high court, that means you are taking away the power of the high court.
Correct.
And if any statute takes away the power of the high court, that is judicial review power under the constitution, then the statute itself, that provision itself is unconstitutional. On that line, that provision was interpreted and said that to this extent this provision is unconstitutional, and then Supreme Court made it clear that hereafter every decision of the tribunal shall be challengeable in the high court, and that will be before the division bench of the high court.
Okay.
And that will be by way of a writ petition.
Okay.
So we challenge, suppose we lose in the CAT or MAT, we file a petition in the high court, writ petition in the high court challenging that order, and that will go to the division bench.
Appellate.
Appellate. It doesn't make a difference, because in only few high courts there is provision like appellate and original.
But as far as
Rest of-
Bombay is concerned, it goes to appellate.
You can go either in appellate or original. It doesn't make a difference,
Okay.
because both tribunals are in Mumbai, so you can go in original side also, or
Okay.
if you go in appellate also, that will not be a big problem. So you can
Okay.
choose whatever is easy for you.
Okay.
That is the case.
Sir, one more thing is, at how many places MAT is there? Physically, offices of MAT.
In Maharashtra, as we have 4 benches of the High Court, including principal bench,
Yes.
we have Mumbai, Nagpur, Aurangabad, and Goa.
Yeah.
Okay, but Maharashtra Administrative Tribunal is of Maharashtra state, so we have the benches in Nagpur, Aurangabad, and Mumbai. And Goa is a different state,
Correct.
so Maharashtra government has no power to make a tribunal for the Goa state. High Court is a different altogether, So in Maharashtra we have MAT, Principal Bench Mumbai, Nagpur Bench, Aurangabad Bench.
Okay.
CAT is only one tribunal for the entire country. It has its headquarter at Delhi, that is Principal Bench, and it has got almost 18 benches over the different
Various places in
various
India.
places. We have Mumbai, Hyderabad, in Gujarat, Ahmedabad, Bangalore, Jabalpur, Kolkata, Orissa, Kerala, Tamil Nadu, Chennai. So these are the benches. They are in Lucknow,
Okay.
UP, in Patna.
Okay.
So we have different such benches of the CAT, and they deal with the and in for example Mumbai we have the Bombay bench. It covers not only our Maharashtra state, it also covers some other portion, say cases coming from Goa also, as far as CAT is concerned,
Okay.
because that is central government, no.
Correct.
So one bench may cover 2 states also of the central government,
Okay.
but the state government will have its own tribunal.
Okay.
And notably there are some states, unfortunately, where there is no even state tribunal.
Okay.
So they are yet to establish the tribunal. In Maharashtra, interestingly, let me tell you, because Maharashtra tribunal is very efficient one, because as compared to other courts, somebody who goes to MAT will get the justice quickly, within few months also. And in case of say transfer is one of the lucrative businesses of the government, no. Transfer is a lucrative business, so people go to MAT and get the stay immediately. So government gets aggrieved by the MAT that the MAT is interfering, so we will close down the MAT. So that is not possible, but they have done so many attempts to close down the MAT also.
Okay.
Maharashtra, many of the times, but then it is not possible, because ultimately there must be some tribunal, no.
Correct.
So we have tribunal, thankfully.
That actually leads my next question as to what is the disposal time of the complaint which is filed before MAT or CAT?
Yeah. Actually, there is no such statutorily laid down any period during which the case has to be disposed of. However, MAT as compared to CAT is very efficient.
Okay.
Sometimes we get orders within month also.
Okay.
In my personal practice, I got so many orders within few months.
Final disposal. Okay.
It depends upon the existing judges also. It depends upon the situation also. Sometimes case may go on for 2-3 years. But in any case, MAT is very efficient, and within even a case like dismissal from service or removal from service, 2-3 years you will get final judgment.
Okay. Sir, who are appointed to hear the case?
That is also very important. Actually, MAT and CAT, this is a kind of administration dealing with the administrative law. So there is a scheme of law that the tribunal must consist of division bench, and that division bench must consist of 1 judicial member and 1 administrative member.
Okay.
So in MAT or CAT, we have 2 judicial members and 2 administrative members in 1 bench. In Maharashtra, now in Mumbai, there are 2 judicial members and 2 administrative members. So division bench will always consist of 1 member coming from judiciary, that is judge, and 1 from the administration. So administration, all the retired secretaries, they can apply.
Okay.
Existing secretaries of the government who have got enormous experience in the service administration while working as a IAS. Now recently it happened actually for the first time that our retired DGP, that is Praveen Dikshit, was also appointed as a administrative member of the MAT. He retired recently.
Okay.
Presently, we do have one Sri Bhagwan, administrative member of MAT. He is actually from the Indian Forest Service,
Okay.
IFS. So, people who are having enormous experience in the administration while they are in the service of the government, either central, state, doesn't make difference, they are also appointed as the administrative member.
Okay.
And there cannot be a bench consisting of two members of the same category.
Okay.
For example, two judicial member cannot sit and decide the case. Two administrative member cannot sit and decide the case.
Okay.
As far as single bench is concerned, there is single bench also.
Okay.
So there is a categorization of cases. For example, matters which are pertaining to dismissal from service, major penalty, removal, dismissal, compulsory retirement, reduction into rank, promotion, pay scale. These are the matters which go to the division bench.
Okay.
And remaining matters, for example, suspension, transfer, and then somebody is removed from service but still is occupying the accommodation given by the government. Somebody has taken extra money from the government by way of mistake, etc. So government starts recovering that amount from that fellow. That is recovery proceeding. These kind of proceeding will go to the single bench. A single bench may be sometimes judicial member as well as sometimes administrative member. Even this is also highly controversial. Let me tell you what happened. The Supreme Court had occasion in one case coming from our MP, B.R. Thackeray versus State of Madhya Pradesh. You can find that case in our Indian Canon also freely available. Or B.R. Thackeray versus MP or MP versus B.R. Thackeray. Exactly, I don't know. In that, Supreme Court made very interesting interpretation. It said that powers of the tribunal as conferred by the Act cannot be exercised by the administrative member sitting singly.
Okay.
So that means actually this interpretation that powers of the tribunal, because Act says tribunal, no?
Correct.
Now bench, single bench, division bench, that is what we say, but when judge sits, it is a tribunal, isn't it? Like court. So powers of the tribunal as conferred under the Act cannot be exercised by the administrative member sitting singly. That is the provision.
Okay.
That is the Supreme Court said.
Okay.
So that meant actually, in effect, that administrative member can be always in the division bench. He should not be sitting singly and dispose the matter finally. Supreme Court made it clear that however, the administrative member sitting singly can deal with the matters but will not dispose the matter finally.
Okay.
But in practice, they do not follow this one, and even our advocates also do not take the objection, therefore it goes on.
Okay.
But this is the legal exact position.
Okay. And sir, you said me how the administrative member comes. I want to know how the judicial member comes. Sitting judges are appointed or separate judges are appointed?
Yes. Only as far as the chairman is concerned, the Maharashtra tribunal chairman say or the central government tribunal says, the law requires that it must be a retired High Court judge.
Okay.
So now just 2 days before notification came, Ranjit More, who is from our Bombay,
yes,
and prior to retirement he got elevated to the Chief Justice position of Tripura High Court or Meghalaya High Court. After he retired, our vacancy of the CAT chairman was there, so he is appointed now as the chairman of the CAT.
Okay.
Ranjit More. Now he will sit in principal bench Delhi.
Okay.
So as far as chairman is concerned, that is requirement of law that it must be a retired judge of the High Court.
Okay.
Retired or existing,
Okay.
who is or has been. That is the exact word used in the statute. So it can be a normally working High Court judge will not go.
Will not go.
Okay. Other member, judicial member, same. But that is not the only qualification. Third is also there. One who is qualified to become High Court judge. Now qualified to become High Court judge would mean a person, a lawyer with 10 years practice. Isn't it?
Correct.
Constitution requires that somebody who completes 10 years as a standing at bar will be qualified to become High Court judge. So even such member of bar can also be appointed as a judicial member in the CAT or the MAT.
Okay.
So we do have often recently one of our member, in fact 2 of our member from the CAT have been appointed as judicial member. One is Patni madam, recently got appointed as a judicial member, and before that I think 2-3 years before one HP Shah, Hina Shah, She was appearing in many of the cases against me also in one department, and she was a panel counsel. She got also appointed as a judicial member. Presently, she is posted in, I think, Jodhpur or Udaipur something.
Okay.
So, a lawyer with 10 years practice is also qualified to become a judicial member. There is a competitive examination like any other competitive examination.
Like JMFC exam, there will be same category of exam for this?
Not same category. The exam is consisting only of interview, not
Okay.
like written, etc.
Okay.
That is the only change.
Okay.
But anyone who is interested can participate into that process. Central government will notify or the state government will notify that we are filling up the vacancy. If you are interested, you can apply.
Okay.
Any lawyer, practicing lawyer, that is the case. As far as chairman is concerned, that has to be only the retired judge. That is the position.
Sir, now just coming to our conclusion,
Yeah.
or rather end.
Yeah.
In the whole process, we have not spoken anything about labor code.
Yeah.
Because the moment people feel, service law,
Yes,
first thing which is there in the common man
where
is the labor code. So, just tell me what is the difference? Because entire, you have not spoken anything about
correct. Actually, this is often a case of confusion as to where to go, in what court we should go. In fact, when I was in the third year of my law, that time this question used to hover my mind, because as a lawyer you must be aware where the remedy lies. You should be aware that this is the court, I can go there and claim the relief.
Correct.
If you mistake that, your entire efforts for the years together will go in vain.
Correct.
After putting so many efforts, etc., the same confusion arises in many of the cases. So for that, the simple formula I will tell you. We have Industrial Dispute Act, which defines as to what is the industry. Okay, and which also defines as to who is the workman.
Correct.
Simpliciter, somebody who falls into definition of workman. Now again here, say for example, in MAT, as I initially said, MAT, CAT, these are the tribunals for the government servants.
Correct.
Okay, but there are employees working in the private industries, so they cannot go to MAT or CAT. So for them, what is the remedy? Is only the labor code.
Labor code.
Simpliciter. Okay. In some cases, we do have the central government come labor tribunal, labor court. That is called CGIT. We have at Chembur, Piridarshan is something. That is central government industrial tribunal come labor court.
Okay.
There, only those who are working in the industry controlled by the government of India.
Okay.
Normally, central government has so many public undertaking. Like in Mumbai, we have shipping corporation, isn't it? So in shipping corporation, the employees who fall into definition of workman can also choose the forum of the CGIT.
Okay.
Can also choose the forum of the High Court.
Okay.
They cannot go to the CAT because that has not been brought under the purview of the CAT. Because shipping corporation is not the government. It is only undertaking of the government. Though it is a state within the meaning of Article 12, so that writ petition is maintainable, but that doesn't bring it under the purview of the Administrative Tribunal Act.
Okay.
So simple formula is that the person who falls into definition of workman can always go to the labor court.
Okay.
Because the definition of workman is very clear. And those who are working in the private employees, private industries, not controlled by any government, they will have only one forum, that is labor court.
Okay.
Then initially, as per the Industrial Dispute Act itself provides the mechanism. Initially, you have to make your grievance to the officer, that is conciliation officer. Conciliation proceeding will go on, and then if it is successful, he will make a report. The grievance is sorted out. If it doesn't get sorted out, he will make a report to the government, respective government. If industry is private and within the state of Maharashtra, Maharashtra government will have the labor officer, labor commissioner. He will make a reference, and then that reference will be the beginning of the proceeding before the labor court.
Okay.
In some cases, for example, somebody is being employed for long time without giving the permanency of service upon him. That amounts to unfair labor practice. Okay. there is a requirement of that fellow, and for long time work is of perennial nature. For example, in any office, for example, say the work of peon, whose work is to keep the office clean. Now this is required permanently, no?
Correct.
It is not that today we make the office clean, tomorrow it is not required. It is required forever.
Correct.
So there is a position of that fellow forever, that perennially, but still the governments are using, or the authorities are using, or even the private employer are using such on temporary basis, daily wages for long time. That actually amounts to unfair labor practice within the meaning of labor laws.
Okay.
With such grievance also one can go to the labor code.
Okay.
So this is called normally ULP complaint, unfair labor practice complaint.
Okay.
So this is general idea, as under what circumstances we can go to
labor.
And let me tell you again interesting case. Employees of the government working like in a railway department. Okay. Now in railway, employees from group C, group D may also fall within the meaning of workman, because railway is a industry. Railway department is held to be industry. So once it is industry, then also labor laws come into place.
Okay.
Because Industrial Dispute Act will come into place.
Correct.
So the employees working in railway, falling within the definition of workman, have two options. They can choose labor code or they can choose the CAT.
CAT. Both options.
Similar will be the case of the Maharashtra government. Now we have in Maharashtra so many undertakings of the government of Maharashtra. That is forest department. That forest department is also there is some corporation under the name of forest. That department is held to be the industry.
Okay.
And again same logic will come into place. The employees working in that department, falling within the definition of workman, will go to MAT as well as the labor code.
They have option.
So there is a concurrent jurisdiction. Then the doctrine of election will come into place. According to convenience, he can choose, and court is bound to entertain his case.
Okay.
Court will not say you can go there also, so go there. Not like that.
Okay.
So this is the situation.
Sir, before concluding,
Yeah.
I would like to know how you were inclined to enter this segment of practice. How you entered this segment particular?
Actually, that is also very interesting, story. When I came here, I actually belong to the Nanded city,
Okay.
Marathwada, and for Marathwada we have a separate bench at Aurangabad. Okay, so normally cases which are decided in our place, that is area where I come from, will go to the Aurangabad bench. They will not come to Bombay.
Correct.
So I did not have option to go to our bar and to meet our friends and to request them to at least send cases to me. Nothing like that. So I was left with the option to whatever case comes, I will accept here at the beginning. So initially 1 or 2 cases came just by luck, and I handled those cases, and in that process I came to read one judgment. I do often tell my all friends, newcomers, juniors, if you want to practice in service law, just read one judgment. It will create interest within you. It will make you perfect.
Okay.
That case is decided way back in 1958. That is very famous case, Purushottam Lal Dhingra versus Union of India.
Okay.
Little bit big case, voluminous case, but I read that one case. That reading of that case created an interest within me, that this is very interesting branch of law.
Okay.
And it is because it is part of constitutional law. Isn't it?
Correct.
So Article 16 provides for the appointment. Article 16 confers a right on everybody to compete for the public post.
Correct.
So this is a fundamental right. Entering into service is a fundamental right. Participating into competitive exam is a fundamental right as per the constitution. So we go to MAT or CAT in High Court in selection matters. This is a fundamental right. So it is a part of constitutional law. So anyone who has got interest or inclination into understanding or practicing constitutional law, for these kind of people, this branch will not be difficult.
Okay.
So that is how from beginning I had interest in the constitutional study. So because of that, my understanding of the constitutional law helped me a lot to understand these tedious concepts of service law. So that is how I became a practitioner in the service law.
Okay.
But I do not claim to be an expert or the only service law practitioner. I have dealt with different matters, different field. I do have criminal matters. I have conducted appeals, anti-corruption matters,
Okay.
conviction matters, general our traditional
Practice
matters
also.
also, practice also. But what happens, once you go on producing the good results, people will bring the similar cases to you,
Correct.
and they will brand you that he is an expert in service law. That is what happens actually.
Okay. Panchal sir,
Yes.
thank you very much for giving your
Yeah,
time.
thank you.
And telling us the entire concept, because this was everything was new to us to hear
Yeah.
all this.
Yeah.
It's very tedious and complicated.
Yeah.
So thank you very much. This is a small token from
Thank
us
you.
to you.
Thank you.